Peter Shane, our speaker today, is a towering figure in U.S. constitutional and administrative law. And he's also, in my experience, incredibly nice, and not just because he agreed to talk to us today. More formally, Peter is an emeritus chaired professor at Ohio State and has now moved his academic flag to NYU, where he's an adjunct professor. He's served in the executive branch, at the Administrative Conference of the United States, been a law school dean, visited at many law schools, and is now on the board of directors of the American Constitution Society. Peter is the author, I learned from the internet, of 60 articles and book chapters, which I guess means I've got about 40 to go. He's also the author or co-author of 8 books, including the administrative law casebook. I do want to mention one of his books in particular, a very important book on separation of powers called Madison's Nightmare, Executive Power and the Threat to American Democracy, published in 2009, making it both truly timely and indeed prescient. I'm absolutely delighted to turn the Zoom over to Peter Shane to discuss the Unitary Executive and its critics. Thank you, Peter, for joining us today.
Michael, it's really my privilege and pleasure to do so. You and I go back a ways. We've known each other quite some time. Just two slight corrections to that very generous intro. The Executive said I've written at least 70 articles by this point. Not that anybody's counting. And unfortunately—
Fix your webpage.
Well, I will update it. And the second thing is, sadly for me, I have term limited out of the American Constitution Society Board of Directors. So my term actually just ended. Unfortunately, I have to put that in the past tense, although I'm still very active in ACS, and I'm always eager to get other people active as well. The topic about which we'll be speaking today seems to be one of considerable interest. I'm sure you get asked about it a lot, as have I. I will just say there is a former member of Congress who's been very active in congressional studies. He's been a lecturer at Princeton for some time. His name is Mickey Edwards. And he has always been a little miffed at me, always, for the last 15 years, because he was working on a manuscript about Congress that he wanted to call Madison's Nightmare. And I got the title first. So, but we've made up since then. So what are we talking about when we talk about unitary executive theory? As a foundation, well, let me start by saying that Steve Calabrese, who's one of the kind of leading scholars in favor of unitary executive theory, once wrote that unitary executive theory confronts the question whether we have more than one president. That's not accurate. Everybody agrees we have only one president. We do not have a council of revision. There is one president of the United States. The question is a question of presidential authority, and in particular, the president's authority with regard to the rest of the executive branch or the executive establishment. And the foundational premise of unitary executive theory, pretty much, whatever author you're talking about, is that Article 2 of the Constitution guarantees the president control over the discretionary functions of the executive branch. And by discretionary functions, I mean to include not only functions that are vested in the president by the Constitution, the discretion whether to pardon someone, to negotiate a treaty, and so forth, but also, very importantly, discretion that the executive branch enjoys because Congress has delegated some kind of regulatory or policymaking authority to the executive branch. Anything where anybody in the executive branch gets to exercise their judgment, if you believe in unitary executive theory, what you're talking about is the president being able to control those exercises of judgment. Now, the theory comes in different flavors. That is, there are more or less ambitious or aggressive versions of the theory. For years, I'd assumed that what the fight was about was just over whether the president has plenary power, complete power to fire all principal officers, heads of departments and other persons who, by virtue of their function, are regarded as principal officers. But there are some who insist that actually the unitary executive entitles the president to removal power over all officers who assist in the exercise of executive power, including so-called inferior officers, officers who report to principal officers. And then I suppose, I don't know if you grade these in terms of aggressiveness, but another version of this might be the power to command directly how discretionary power is exercised. Now, what would that look like? EPA has statutory authority to regulate with regard to air pollution. Under this flavor of unitary executive theory, the president is constitutionally entitled to command the Environmental Protection Agency to take a particular regulatory approach. He gets to direct the way in which their rulemaking discretion is exercised. And a potential corollary of that is when asked to defend in court the way in which the agency has exercised discretion, EPA could say, well, we did what we did because the president ordered us to. That would be an answer to that question. Perhaps the most aggressive version of this is that the president actually has the power, if the president so chooses, to execute all functions of the executive branch personally. So when Congress vests authority in EPA or the Department of Labor or the National Labor Relations Board, whatever it is, it's kind of a first stop that the president, if the president so chooses, could decide, I feel like enforcing the National Labor Relations Act myself. So I'm going to do that. I'm going to do EPA rulemaking myself. Now, I do want to say, I'm not making this up. There is some serious scholarly work that, offers a defense of this theory, although I think it's wrong. But it has a very important implication if you buy it, which is that if you're the head of an agency, maybe the attorney general, maybe the secretary of labor or whatever, you might have thought that your authority to get involved in something, regulating the environment, health and human services, regulating, Medicare, whatever, you may think that really depends on Congress's decision to vest authority in you. But if you believe this version of unitary executive theory, then you are also dependent on the president's willingness to let you proceed on your own and not interfere with the way in which you're exercising discretion. You become as dependent on the president for your authority as you would be dependent on Congress. So, of course, the Constitution doesn't say anything about this explicitly. There's no executive removal power even mentioned in the Constitution. So, where does this come from? Well, supposedly, if you're an advocate of the theory, you think it comes from perhaps the vesting clause. This is the sentence in Article 2 that says, the executive power shall be vested in a president of the United States of America. Or maybe it comes from what is usually called the take care clause. The president, referred to in the Constitution as he, shall take care that the laws be faithfully executed. And sometimes, again, depending on the writer, there's some alchemy that puts these two things together and gives the president some of this unitary executive power that can't be regulated by the other branches. So as I said, this scholarly debate for a long time just centered on the removal power. But our current president is all in on the most extreme view. And rather than my trying to capture it, I thought I would let him speak for himself.
Then I have an Article 2 where I have the right to do whatever I want as president, but I don't even talk about that. It's a thing called Article 2. Nobody ever mentions Article 2.
More importantly, Article 2 allows me to do whatever I want. Article 2 would have allowed me to fire him.
So it sounds
but
like
I wasn't going to fire. You know why? Because I watched Richard Nixon go around firing everybody, and that didn't work out too well. So very simply, Article 2 would allow me to do.
I could have done anything I wanted. I don't even bring it up because we don't even get there. Absolutely, I have Article 2.
It gives me all of these rights at a level that nobody has ever seen before. We don't even talk about Article 2. So, they ruled no collusion, no obstruction. Very simple.
It is, Trump has been mocked for this statement. But I guess what I want to say, well, first of all, I want to say I'm talking about Article 2. So people are talking about Article 2. But the more important point is that what he is saying is probably not all that different from the way in which his lawyers are translating what they hear in the separation of powers opinions of the Roberts Court, particularly not even just the holdings of the cases, but the court's dicta on the nature of the constitutional presidency. So what are they saying? And when I say they, I refer to the Roberts Court, and Chief Justice Roberts is not the only person who has addressed these issues in important ways, but the most important cases are typically cases in which he has chosen to write the opinion. So I speak of, a Roberts narrative of the constitutional presidency, a narrative that he insists is rooted in history, that really has, I think, three essential elements to it. The first element I call the one-person branch theory. It was articulated in a case called Trump versus Mazars, which technically was just, all it was about was whether Congress was entitled to subpoena from third parties some financial records regarding the president and his former businesses. This occurred during the first term that President Trump served. But he's repeated this since. It's been repeated in the immunity case last year. The president occupies a unique position in the constitutional scheme as the only person who alone composes a branch of government. So that's element one of the Chief Justice's narrative. The second element of the theory I call the unbreakable chain of command element. And again, now I'm quoting Chief Justice Roberts. Today, thousands of officers wield executive power on behalf of the president in the name of the United States. That power acquires its legitimacy and accountability to the public through a clear and effective chain of command down from the president on whom all the people vote. So that is a particular vision of the nature of democratic accountability. We all, again, I'm quoting, all the people get to vote for president. That gives the president a kind of democratic imprimatur that the president can pass on down the chain of command as long as people are directly accountable to the president. And the third element, which comes out of, again, dicta in the immunity case, is the uncheckable power element, where the Chief Justice wrote that Congress cannot act on and courts cannot examine the president's actions on subjects within his, what the court calls, conclusive and preclusive constitutional authority. And again, if you read the immunity opinion, you'll see that among the powers of the president that they consider conclusive and preclusive is the removal power and the powers with regard to controlling the investigative and prosecutorial decision-making of the executive branch. You may have seen, there was a clip, and I haven't captured it here, where the president was asked basically if he ordered the search of his former National Security Advisor, John Bolton's home and office. And he said, no, I didn't. I could have. I'm the chief law enforcement officer. I could have. And that's the power that the Roberts Court says is conclusive and preclusive. Now, I like to say, I've often said that I really have only three problems with the theory. It mangles the constitutional text, it flouts constitutional history, and it ignores the institutional dangers of adopting this as a reading of the Constitution. Other than that, it's a lovely theory. Now, what do I think to, I don't know if this is a spoiler or not. Let me just give you what I think is the likeliest coherent reading of the text. And by likeliest, I think this is what even folks in 1789 would have inferred from the text, although I want to say I'm not an originalist, and I want to talk about that in a few moments. But I think what they would have assumed or inferred, there is a president of the United States who's going to head the executive branch. Powers granted to the president are executive. They're related to the execution of the law, but it's Congress who determines how the law is best executed. I know that because there's a clause under Article 1 that says that Congress has the power to make all laws necessary and proper for carrying into execution all powers vested by the Constitution in any officer or department of the government. So I think that to me sounds like Congress determines how the law is best executed. In doing so, Congress will create executive departments and assign them duties. I know that because Article 2 refers to executive departments that have duties. The president supervises the execution of the law. He takes care that the laws be faithfully executed. He makes sure that the laws are executed faithfully to the law. In doing so, the president gets to demand reports from the heads of departments, executive departments, and I think it is probably an inference that Congress cannot take that power away. If he wants to insist on knowing what the departments are doing, he can demand their opinions in writing. And the departments will also include not just the heads of the departments who are answerable to the president, but inferior officers. And interestingly, these inferior officers may be appointed by the president with advice and consent of the Senate. That's kind of a constitutional fallback. But if someone is an inferior officer, Congress has other options. They could allow the president to appoint an inferior officer, him or herself. They could allow department heads to appoint the inferior officers. And very interestingly, they could allow courts of law to appoint inferior officers, which also sounds not so unitary. Now, I just want to put this out there because I think this, to me, is what the Constitution, soundly read, would suggest. So where does the Roberts narrative come from? Well, the first, and it's treated in a kind of iconic way, the first real statement of the one-person branch theory comes from the late Justice Scalia. And it was in his dissent in Morrison versus Olson. This is the 1988 case that upheld the independent counsel system that Congress had enacted after Watergate. It was a 7-1 opinion. Justice Kennedy was on the court but recused himself. I think I can guess that if Justice Kennedy had voted, he probably would have been with Justice Scalia. Whether he would have been with him on the precise wording of his opinion, I don't know. But Justice Scalia, reflecting on Article 2, Section 1, Clause 1 of the Constitution, notes that the executive power shall be vested in the President of the United States and says, this does not mean some of the executive power, but all of the executive power. And this is, again, even though this was a one-person dissent at the time, and I hasten to add, italics were in the original. So he takes this, this is a core premise. This has become a kind of article of faith for defenders of unitary executive theory. Now, I haven't excerpted the vesting clause. The executive power shall be vested in a president of the United States. I don't see the word all. You probably don't see the word all. How does it get there? Well, it gets there through what linguists call pragmatic enrichment. Victoria Norris, who's a wonderful scholar, teaches at Georgetown, has written about this, a number of articles about this, one of which is called Reclaiming the Constitutional Text from Originalism. And she focuses particularly on the problem of, this particular claim of Justice Scalia's. But her explanation is, faced with skimpy texts, I'll give you a mundane example in a moment, interpreters are likely to interpolate or add to the meaning of raw text when seeking to apply the text to a particular context. Linguists call these pragmatic enrichments or pragmatic inferences. Put more colloquially, interpreters tend to fill in the blanks in any communication. And what's important about this is recognizing that when you do this, and we do this all the time, I just took a drive to upstate New York, and there was, road work going on. And at what seemed to be where all of the, orange barrels stopped, and I couldn't find any more bulldozers, there was a sign that said "End Construction." I knew that wasn't a protest sign. I knew this was not, calling for an end to construction. This was a signal that the construction zone was over. I've never quite understood why the word "of" was thought so costly that it never appears on those signs. But end construction, I know that end construction is not a protest sign because of the context. One of my favorite examples, which may be meaningful to folks in Miami, is this rather customary sign on many a restaurant on the beach: no shirt, no shoes, no service. Well, if I'm wearing a t-shirt and shoes and nothing else, is that enough clothing to get me service? Pretty sure the answer is no, unless it's a very, very long shirt. Similarly, if I'm asked, someone approaches me, they're wearing a dress. I'm wearing a dress. Am I going to be served? I'm not wearing a shirt. Yes, I know what this sign means. What this sign means is we have a certain level of modesty of dress that we think is appropriate to our comfort and the comfort of other patrons that we insist on. And taking, beachcombing males as the paradigm case, we want at least some kind of shirt. We want something on your feet, or we're not going to serve you. We're not saying you can go without pants. We're not saying we're not going to serve people in dresses. Everything that I just said has gone beyond what that sign just said. I know what that sign means because of where it appears, because I've experienced how restaurants behave when that sign is on I go into the restaurant, I see a bunch of people, not wearing shirts, and they're all wearing pants. I know how this is going to work out. That's pragmatic enrichment. So pragmatic enrichment, the way you can ignore it, the way Justice Scalia ignores it, is basically by treating the vesting clause in isolation from everything else in the Constitution. For example, what about the other branches' vesting clauses? Congress gets a charter that starts with the line, all legislative powers herein granted shall be vested. I guess the framers knew the word all. Right there it is. What do the courts get? They get the judicial power of the United States. That sounds pretty comprehensive. Now, it does say the executive power shall be vested in the president, but the word "the" is doing a lot of work if you think it means all the executive power. If I tell you the dessert's my favorite part of the meal, am I telling you anything different from dessert's my favorite part of the meal? If I say the executive power is vested in the president, is that saying anything different from executive power is vested in the president? I'm characterizing the power. I'm not necessarily giving him all of the power. And that idea is reinforced by the fact that you have the opinions clause, which says that the president may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices. These departments, they seem to exercise some kind of authority. It sounds executive. And what about that Congress thing? Well, again, you get to the necessary and proper clause. Not only does the framers know the word all, they like it here so much they use it repeatedly. They say that Congress has the power to make all laws necessary and proper for carrying into execution the foregoing powers which are of Congress, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So if you're looking for comprehensiveness, there it is. And by the way, not only is all of this being ignored by Justice Scalia, but we know he can't be correct about all the executive power just by reading a few more sentences into Article 2. Article 2 says that the president shares the appointments power with the Senate. So he doesn't have all the executive power. The Senate has some. The Senate shares the treaty power, another executive power that is shared. And so, by the way, at the most expansive reading that you could possibly give the vesting clause is that executive power is vested in the president of the United States, except as it is shared elsewhere. Now, that would be, that much is inescapable from reading the rest of Article 2. But then there's this other problem, which is Congress may by law vest the appointment of inferior officers in courts of law, which means that they would not necessarily be directly accountable to the president. So there are a lot of problems just with the text. So what about history? What about history? Do we do better on history? And here, I don't want to seem, too dismissive of the court, but I do think they're either non-originalist, maybe that's what's going on, or if they're pretending they're originalist, then it's just phony originalism. The kind of originalism that this court subscribes to, and that is, I would say, the adherents of unitary executive theory whose work I'm familiar with adhere to, has come to be called original plain meaning originalism. The idea is we're giving the text the meaning it would have conveyed to a reasonable person at the time of the framing. And by the way, I take that definition of originalism from the work of John McGinnis, who's a very smart originalist from Northwestern. We disagree about a lot of things, but I thought, rather than giving a non-originalist definition of originalism, I would take an originalist definition. And this is what Professor McGinnis thinks originalism means. And I just want to say that it's unlikely that any reasonable ratifier of the Constitution in 1789 would have attributed to the vesting clause or to the take care clause either a comprehensive removal power, even with regard to criminal prosecution, by the way, or the authority to execute the law personally. And there are a variety of reasons I suspect that my inference is correct. First of all, and I think this is pretty well known, Jed Sugarman has done a lot of work on this. I think Michael McConnell has indicated this as well. And Professor McConnell, formerly on the 10th Circuit, now at Stanford, has the same view I have on this, that the vesting clause does not imply that which is vested is immune to regulation or exclusive. Professor McConnell says, if the only source of unitary executive power was the vesting clause, Congress would still be entitled to regulate it. Vesting just means the placement. It doesn't mean that it can't be subject to the control or supervision of others. The take care clause is kind of weird as a source of power because it is phrased in this conspicuously passive voice. The president shall take care that the laws be faithfully executed, which is very different from the president shall execute the laws. It sounds like a duty, not like a power source. And indeed, historically, it probably comes from, going back to the prohibition in Magna Carta on the authority of the king to suspend the operation of law. What President Trump did on the very first day of his second term, saying that the statutory TikTok ban was not going to be enforced, that is a core example of what the take care clause was intended, in my view, to prohibit, suspending the execution of the laws. So I don't regard it, I think the ordinary reader of that in 1789 wouldn't have seen it as a source of power. They would have seen it as a duty not to suspend the law. That opinions clause, and I am indebted to Professor Sugarman for this point, there are lots of early state constitutions in which the legislature or the governor is entitled to ask for reports in writing, opinions in writing. Typically, it's reports. But you can tell in the context that this is almost always a signal of some kind of arm's length-ish relationship between the asker and the responder. You don't need to guarantee that the legislature can demand reports from someone if they have the power directly to control them. You don't need to give that power to the governor if the governor can directly control them. I think the opinions clause, the logical implication of the opinions clause is that whatever the president's relationship is, it's not one of direct control. If he could directly control the person, then adding into, not only can I control you, but I can demand your opinions in writing. That just is a weird, would be a constitutional weirdness. And I also think, if you read the work of the Unitarians, and I mean the constitutional Unitarians, not the religious group, often their interpretation of what executive power means is rooted in their reading or understanding of what they think royal prerogative would have meant in 1789. And there are lots of historical reasons to think that that's not accurate, that would not be the appropriate baseline. It's not, there's a lot of problems I have with their history, but that's not all the problems. Alexander Hamilton, writing in the Federalist, wrote that the president would not have the power to remove the people appointed with the advice and consent of the Senate. He said a change in the chief magistrate would, he said because of this, because the president would need to get the Senate's consent to fire anybody that they had helped to hire. A change in the chief magistrate would not occasion so violent or so general a revolution in the offices of the government as might be expected if he, the president, were the sole dispenser of offices. Now, my friends on the other side of this debate often say, but by the time of the first Congress, Alexander Hamilton changed his mind. Okay, fine. He changed his mind. The question is what someone voting on the Constitution in 1788 or 1789 thought they were voting on. They were given a pamphlet written by this fellow Publius, of whom Alexander Hamilton was, I guess, in a sense, 1/3, but actually closer to, much more than that. If you were reading the Federalist and you were wondering, well, how much presidential removal power am I signing on to? Hamilton is telling you you're not signing on to comprehensive removal power. And that's what counts, what people would have inferred in 1789. Now, it is true that 1789, people are voting. We see the ratification of the first, our only federal constitution. This is a new thing, but it's not the first constitution written on the North American continent. There were all kinds of state constitutions that were written, some just before, some just after the framing of the federal constitution. And if you look at those constitutions, again, both before and after, the ones that are closest in time to the federal constitution frequently did give the legislature control over key administrators. They frequently did not assume that vesting executive power in a single individual necessarily implied that that individual would have complete control over administration. And an example of this is that all 6 of the first 13 constitutions that mention an attorney general, who, current presidents and the Supreme Court would say is the quintessential executive officer. Well, all of them that mention an attorney general refer to the attorney general in the same clause that they refer to state judges. They refer to, judges and the attorney general shall be, et cetera, subject to, appointed by, whatever. And indeed, it's revealing that the federal statute that created the federal attorney general and provided for the first federal district attorneys was not a Department of Justice Act. We didn't have a Department of Justice until 1870. These officers are created by the Judiciary Act of 1789. Why? Because in 1789, a government prosecutor would be just as likely to be regarded as a judicial officer as an executive officer, notwithstanding what the Roberts Court is currently saying. Now, again, advocates of unitary executive theory often point to what they think were votes in the first Congress that support their view. The first Congress was actually quite eclectic in their institutional design. They vested administrative authority in lots of kinds of institutions. Excuse me while I take a drink of water. Some of those institutions gave the president a lot of control, like the Department of Foreign Affairs, which became the Department of State. Other times, they seemed to give authority to people the president couldn't control. Administrative authority, for example, given directly to the vice president, or as well as to appointed officers that the president would not directly control. Now, there was this thing that has come to be referred to as the decision of 1789. And to make a long story, I hope, short and yet comprehensible, what happened is that there was a draft of the statute creating the Department of Foreign Affairs, which referred to what would happen to where the records of the department would go, basically who would succeed in office if the Secretary of Foreign Affairs were removed by the president. And some people in Congress thought that phrase, if they were removed by the president, implied that presidents needed to have Congress's authority to remove someone. And the thought was, and people who did not want that implication that the president needed congressional authority to remove someone, successfully argued for a change in the wording that's basically made it sound like, if somebody were removed by the president, again, using sort of a passive construction, that this would acknowledge presidential removal could occur, but not imply congressional involvement. If the major case that supports in dicta some of unitary executive theory before the Trump cases was the 1926 case of Myers versus United States. And Chief Justice Taft, who of course had been president, relies very heavily on his reading of this so-called decision of 1789. But it's asking, I think, it's asking a lot for the decision of 1789 to bear this weight. Again, it's Professor Jed Sugarman, who's now at BU, who's I think has done the most meticulous kind of line by line reading of how everybody in Congress was thinking about this issue at the time. We don't have wonderfully complete records because the Senate didn't keep a journal. We know how they voted, but not why. We have summaries of House debates. There's an important diary by Senator Maclay of Pennsylvania that give us some primary source material. But as best Professor Sugarman could figure out, there were 4 different positions held by different members of Congress. Some thought, although this was a minority position, that the only way an officer of the United States, once appointed, could be removed was by impeachment, which is, by the way, the only way that is textually explicit in the Constitution. Some believe that the removal power follows the appointment power. If the Senate's involved in appointing somebody, then the Senate has to be involved in consenting to their removal. That was, Hamilton's position in the Federalist. Some members of Congress believed that the president could remove on his or her own authority, but only if Congress allowed it. That is, it would be dependent on Congress's indulgence in allowing that exercise of authority. And then there were people who believed what Justice Scalia now, or when he was alive, what he believed, which is that Article 2 gives the president plenary removal power. It doesn't require either the consent of the Senate or congressional authority. The final vote, again, I don't want to go through all of this. You can't really tell from who voted and the prior positions that they'd taken in the debate what was the prevailing position. It is just as likely that the plurality position was a requirement of congressional authority as it was that Article 2 vests plenary removal power in the president. So this turns out to be pretty ambiguous evidence on closer inspection. And as for the most ambitious version of a unitary executive theory, that is, does the president get to exercise all this power personally? Well, an early attorney general named William Wirt, he got to be attorney general both for President Monroe and for President John Quincy Adams, was asked this question. That is, there was a big debate about whether how much a particular major who had served, now I'm going to forget if it was in the War of 1812 or the Revolutionary War. I think it was in the War of 1812, how much he was owed by way of compensation for some equipment that he had purchased or uniforms or something like that. And there was a back and forth between Congress, and Congress set up a process, but it was supposed to be, under the statute, an amount determined by an officer in the Department of the Treasury. An accounting officer in the department was given the statutory designation to make the final determination. And apparently that wasn't good enough for the major supporters who wanted the president to second guess that. And the president, at this point, it's John Quincy Adams, asks Attorney General Wirt, can I do this? Can I actually determine the amount and insist that my calculation govern rather than the accounting officer in the department? And this is what the Attorney General said. The requisition of the Constitution is that he being the president, shall take care that the laws be executed. If the laws then require a particular officer to name by name to perform a duty, not only is that officer bound to perform it, but no other officer can perform it without a violation of the law. And were the president to perform it, he would not only be not taking care that the laws be faithfully executed, he would be violating the laws himself. So again, this is after 1789, but these are folks who have lived with the Constitution much closer to its founding. They've seen constitutional developments in the states at a much earlier period. State constitutions written after the federal Constitution, but still in the early decades, often use vesting clause language, take care clause language. They still split power over administration between the governor and sometimes the legislature, sometimes the courts. But I have to say, and again, I hope you'll forgive me if I seem unduly unforgiving of the Roberts Court, but one does question, at least I find myself questioning, their historical seriousness. So here is Chief Justice Roberts in the Silo Law case. Silo Law case was the case that says the president has the constitutional authority to fire the head of any agency if the agency is headed by a single director, including the Consumer Finance Protection Bureau. And Chief Justice Roberts said the framers made the president the most democratic and politically accountable official in government. Well, if they did so, it certainly would have been by accident, because what they thought they were doing was making the president the least electorally accountable official in government. The only officials who were directly accountable to the people were members of the House who could be elected, who were entitled to, voters were entitled to vote for members of the House directly if they could vote for the larger or the only house of a state legislature. Then they could vote directly for the House of Representatives. They couldn't vote for the Senate. The Senate would be elected under the original Constitution by state legislatures. So there's one level of removal. State legislatures, though, could not themselves even elect the president. They could only determine how a group of people called electors would be chosen, and the electors would actually cast ballots for a president. So the president is uniquely insulated not once but twice from the voters of the United States. And this is, again, putting aside all of the limitations on the franchise in 1789. The president this is simply not an accurate description of what the framers had in mind. In the Trump immunity case in 2024, which used this very broad language about presidential authority being conclusive and preclusive, what the Constitution means with regard to presidential immunity, you would think that, an historically minded court, okay, this is in 1789, but you think they would talk about Watergate? They would talk about the pardon that Gerald Ford, who was president of the United States, issued Richard Nixon, who was president of the United States. He accepted the pardon. Seems like they must have thought that a former president, could be prosecuted for even official conduct. Bill Clinton, on his last day of office, signed a non-prosecution deal with the Office of Independent Counsel. What had been Ken Starr's office, he was no longer the person in charge of the office, but he signed a non-prosecution deal in which he agreed to, I think he gave up, or he allowed for his law license in Arkansas to be suspended, and he acknowledged that he had not testified truthfully to the grand jury with regard to his relationship with Monica Lewinsky. Most recently, the Supreme Court, the Trump administration wants this Supreme Court to go all the way and say not only, as it said in Silo Law, that the president can fire the heads of single-headed agencies. They want them to overrule a case called Humphrey's Executive, which said that Congress could put limits on the president's ability to remove heads of multi-member agencies, like the Federal Trade Commission. The Federal Trade Commission was the agency involved in Humphrey's Executive, that Congress could condition those removals on good cause. Well, no doubt in the hope of generating a test case that would lead to the overruling of Humphrey's Executive, President Trump started firing people who were independent principal officers protected by statute against being fired except for good cause. Among them were Gwen Wilcox, who was a member of the National Labor Relations Board, a woman named I'm sorry, there are two of them. And the other person was Kathy, maybe it's Kathy Wilcox, who was the head of, one of them was the head of the Merit Systems Protection Board. One was a member of the National Labor Relations Board. Both enjoyed statutory protection. And both were successful in separate actions in DC District Court. Kathy Harris and Gwen Wilcox. Both of them were successful in district court lawsuits filed in the District of Columbia in getting, not only having their firings declared unconstitutional or unlawful under statute, but getting a preliminary injunction restoring them to being able to hold their office while their cases were on appeal. And the DC Circuit left that preliminary injunction in place. They said, yes, these people can remain in office until this is finally adjudicated by the Supreme Court. The Supreme Court, on an emergency application by the Trump administration, said, no, we're going to lift that stay. While this case is moving forward, the officers will remain fired. They'll remain fired until the DC Circuit issues an opinion on the merits and we get to decide. Now, they knew, members of the court, that one of the big issues in the debate about independent agencies revolves around the Fed. To my knowledge, every modern post-industrial economy includes a central bank with some measure of political independence. This is thought to be very important to investors, very important to the integrity of markets. And the court was warned, if you say the Board of Governors of the Federal Reserve System serves at the pleasure of the president, if you undermine their independence, this could have a disastrous economic effect. And so, even though this was not at all at issue with regard to Ms. Harris or Ms. Wilcox, the court, in granting the emergency application that kept them out of their office while the case is being adjudicated, said, but don't worry about the Fed, because the Federal Reserve, no matter what we decide in Humphrey's Executive and whether it should be overturned, the Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. And I just want to say, there is no resemblance between the Board of Governors of the Federal Reserve, which is a regulatory agency, and the first and second banks, national banks of the United States, which were banks. And I would also say, although it's not as pertinent on this issue, that if you look at the case that allowed or that disallowed Colorado from keeping President Trump off the ballot, the primary ballot in Colorado, even though the Supreme Court of Colorado had upheld a finding that he had engaged in insurrection against the Constitution, again, there's no serious discussion of the history of that part of the 14th Amendment. Okay, you've been very kind. You've listened to me for almost an hour now. And you still may be thinking, okay, I'm not 1,000%, convinced that Professor Shane is absolutely right, but he might be right. There's some ambiguity here. So what should the court do if it recognizes there's some ambiguity in the text? There's ambiguity as to the historical reading, and they're supposedly originalists. Well, I'm critical of the court, not only for what I take to be its analytic flaws, but also for what I think is its hubris. Humphrey's Executive versus the United States, the 1935 case that upheld the Federal Trade Commission, was decided by an extraordinary court. We're talking about a court that included supporters of the New Deal, that included the supposed four horsemen, a reference to the four horsemen of the apocalypse who were opposed to the New Deal. It included Justice Brandeis, Justice Holmes, Chief Justice Holmes. Brandeis included Justice Cardozo. It included Justice Stone. It included Charles Evans Hughes as Chief Justice. I mean, these are heavyweight members of the court. And despite intense philosophical disagreements, and the fact that some of them had been on the court when the Myers case was decided, that decided whatever it decided with regard to postmasters in 1926, they all decided unanimously that it was okay for Congress to create independent agencies. The current court seems on the edge of depriving Congress of the authority to regulate the executive branch on behalf of a historical reading, which, to put it mildly, is highly debatable. And I think that raises the question of what is the court's proper role and whether this kind of formalist originalism makes sense. Even if the ratifiers of 1789 had a genuine consensus understanding as to the constitutional parameters of George Washington's relationship to the federal bureaucracy of the time, should we be bound by it? After all, most 2025 cabinet departments are bigger than the entirety of the federal establishment in 1789. Political partisanship was barely a thing then, although despite the framers' hopes, it was nascent. But they were not dealing with a highly developed, highly polarized partisan political context. They were talking about a government. If George Washington controlled the federal government, he was controlling a government whose impacts on individual citizens were relatively limited in 1789. And in 2025 are all but ubiquitous. And on top of all of that, by now, the practice of independent agencies, and by the way, the Fifth Circuit has read the tea leaves in what the Supreme Court is doing. They think Humphrey's executive is going to be overturned. Jay just last week declared the National Labor Relations Board unconstitutional, even though it's been in business for 90 years. I mean, we have decades upon decades now of public administration practice that gives us a much clearer sense of what these institutions are and how they operate than the court or anybody would have had in 1789. What I would argue is that, sure, we should think about the text of the Constitution, and we should think about which values of the framers, signaled by the text, matter today. And we should operationalize the text to prioritize the most important of those values, given our needs and our challenges. And I think, among the things that I think the framers cared about were administrative efficiency, accountability, both political and legal, adherence to the rule of law, and public integrity. They worried about corruption. I think under contemporary law, we probably have a more developed theory of the role of technical expertise, both its scope and its potential limits than would have been the case in 1789. We certainly have a more democratic conception of accountability than they would have had. But if you put all these values together, I think they argue for what I earlier called the likeliest reading of the text. The president controls the executive branch. His power relates to the execution of the laws. Congress determines how the laws are best executed. Congress creates the departments. The president takes care that the laws are faithfully executed. He has an information gathering role, to be sure, and other roles that Congress may acquiesce in or approve. But very much what the president is entitled to do, particularly in domestic affairs, is up to Congress. And the final complaint, I've told you, I think that the current court is mangling the text, they're flouting the history. I think they're also ignoring the institutional implications of what it means to give the president this scope of power. And for this, I can't really express the thought any better than Justice Story. In the early part of the 19th century, apparently, if you're talented enough, you had time both to be a chaired professor at Harvard and a member on the Supreme Court. I'm sure there are chaired professors at Harvard now who think that they could do both jobs simultaneously. But in any event, Joseph Story didn't. And while he was on the court, he wrote his commentaries on the Constitution of the United States, a 2-volume work that was the preeminent discussion of what the Constitution meant in the antebellum United States. And he was very much opposed to the idea that the president had comprehensive removal power. He said, "It is utterly impossible not to feel that if this unlimited power of removal does exist, it may be made in the hands of a bold and designing man of high ambition and feeble principles, an instrument of the worst oppression and the most vindictive vengeance. It would convert all the officers of the country into the mere tools and creatures of the president. A dependence so servile on one individual would deter men of high and honorable minds from engaging in the public service. And if, contrary to expectation, such men should be brought into office, they would be reduced to the necessity of sacrificing every principle of independence to the will of the chief magistrate, and of exposing themselves to the disgrace of being removed from office, and that too at a time when it might no longer be in their power to engage in other pursuits. This to me has a kind of familiar ring to it, and it was written in 1833, although I happen to pull it from a reprint from 1873. I think the pro-democracy challenge for the administrative state is achieving executive vigor, which the framers wanted, without inviting authoritarianism, and enhancing executive accountability while still allowing the executive branch to function with some kind of efficiency. This, I think we were doing not so badly at this, muddling along before unitary executive theory came along. And it is my hope, it is my dream, it would be my wish that the Roberts Court would, at least out of respect for stare decisis, back off from the most extreme views of its theory and give us a narrative of a constitutional presidency that is more accountable and is not an Article 2 that allows the president to do, to quote our president, whatever he wants.